Good afternoon, sir. Can you see and hear me?
Yes, I can.
Thank you very much. Mr. Morgan, can we just go back to the document we were looking at shortly before lunch to ask one supplemental set of questions on it? It's poll 3072741. And if you remember, I was asking you questions about what evidence was and wasn't disclosed to you about bugs, errors and defects.
Yes.
And difficulties with producing data from Horizon and the extent to which this informed or didn't inform the nice legal point that you developed. And we had looked at the questions that you had asked on page 5 about can Fujitsu get in and change the raw data. Can we look at page 6, please? And if we look at the foot of the page, please. 3 paragraphs from the bottom. This is in the context of some other case. And you say, I would like also to know if it is a genuine one-off, and I would like to know if the number of allegations and the number of paper cases that have occurred, other than the Bajaj and Bilku cases, how many other allegations have been made, and how many have come to trial, and the outcomes of those. These need to be of a particular issue of persistent shortfalls, allegedly attributable to the computer system. First of all, I take it that in line with the evidence you've given previously, you don't remember asking questions of that sort at this remove of time.
I've got no specific recollection. No, I'm just trying to think about what. So I think there must have been mention in my instructions about Bajaj and Bilku, but I can't remember.
What would your interest have been in? I'm sorry, I spoke over you. What would your interest have been in discovering allegations concerning persistent shortfalls attributable to the computer system have been?
Well, obviously, I'd want to know if there was some deficiency in the Horizon system that was causing artificial losses. If there was a problem in there, I wanted to know about it sooner rather than later. The last thing one wants to do is get to 3 or 4 weeks before trial and find that there's been some finding somewhere else that there is a real problem. It's all about risk management and understanding the profile of the evidence.
And where it refers to how many other cases have come to trial and the outcome of those, would you have been interested in both criminal and civil cases? It didn't matter where the allegation had been made of a persistent shortfall attributable to the computer system.
I'd like to say yes. I'm not sure that I was necessarily sufficiently alive to the fact that the Post Office was prosecuting people to have that degree of sophistication in my question. I think it would have just been, at that time, the open question, what other cases are there, and are they showing there's a problem? Without understanding what the allegation is in each individual case and what the outcome is, one's not going to know whether that's going to impact on the evidence that's going to be given in the specific trial in relation to which I was being instructed. But I certainly wanted to understand the overall terrain within which the dispute was going to occur.
And so you would cast the question and therefore the net relatively widely at that stage?
Yes. I'm trying to find out what's going on. I'm saying without being so crude to say, give me full and frank disclosure, I want to know, are there any unexploded landmines that I'm going to step on if I go down a particular course? Is there anything that's going to come out that I should know about now? generally with sophisticated firms of solicitors, they know that that's what you're asking them when you say, what's out there? I think I would have assumed that with Mr. Beezer and Mr. Dilly.
Did you ever get an answer to this question? We've asked about the Fujitsu having access question. Did you get an answer to this question?
I think in relation to this question, and it's only because of documentation that I've read recently, I think that the Bilku case hadn't even been issued. I hesitate to ask a question. I think I'm right in that. And I don't think I ever got an answer in relation to Bajaj.
But what about the wider question?
I didn't get an answer in relation to that, no. At least sorry, that sounds very definite. I do not recall now an answer to that then.
Can we look, please? That can come down, thank you. At FUJ 2015 5767. It's an email exchange which you're included on. It's just over a month before trial. And if we just go to the foot of the page, please. There's an email from Mr. Dilly of the 31st of October to Brian Pinder, and you're on the copy list. Can you see that?
Yes, I can.
And if we just read through it together, one of the witnesses in the Castleton case is Greg Booth, who was the temporary sub-postmaster at Marine Drive branch from the 21st of April to the 28th of May 2004. He's now at Newbury. Greg spoke to me last week and reported that his computer froze whilst he was serving a customer and was partway through a transaction. Transaction had not been settled. It related to a postage label. When he logged back in again, the computer had lost the transaction of £1.27. Computer didn't prompt him to try and recover it. Greg is away this week, but I'll be contacting him upon his return to obtain a supplemental witness statement about this point. Prior to then, Greg's evidence was he'd never known the system lose a transaction. In this particular case, Greg was up £1.27 because he'd taken money from a customer. However, I anticipate the reverse would have happened if he'd been paying money out. Although this is for a small amount, the principle on the face of it seems concerning because it suggests that the Horizon system can, albeit rarely, lose transactions. Castleton solicitors will try to exploit any weakness, and we must be prepared for a possible attack on this point. Our counsel has requested that Fujitsu review the Newbury Post Office's Horizon data for those days period to see if you can tell whether the system froze and lost the transaction and what the explanation may be. We have to serve witness statements very shortly. I will have to prepare a supplemental witness statement. Now, Mr. Booth, I think you'll recall, was Gregory Booth, was one of 3 sub-postmasters that operated the Marine Drive branch immediately after Mr. Castleton had been suspended and was ultimately dismissed. And his evidence was, can you help with this, adduced at trial to seek to demonstrate that those who operated the Marine Drive branch after Mr. Castleton left did so without difficulties being caused by the Horizon system.
I don't remember now, but I'll take your word for it that that's an accurate reflection of the record.
In due course, we needn't turn it up. The judge referred to Mr. Booth's evidence, it's paragraph 24 of his judgment, saying Mr. Booth experienced no significant discrepancies other than 2, which were deliberately induced to check the operation of the Horizon system, having regard to Mr. Castleton's allegations. At the foot of the previous page, just scroll down. Thank you. Your solicitor says, although this is for a small amount, the principle on the face of it seems concerning because it suggests that Horizon can, albeit rarely, lose transactions. Would your view be the same, irrespective of the amount? It's
yes,
the principle.
Sorry, I didn't mean to overspeak. Yes, and without wishing to try to look too wise after the event, that's why I'm asking for Fujitsu to have a look at it and explain it.
And it seems that even before you received this email, you had spoken to or communicated in some way with Mr. Dilly, because he says our counsel has requested that Fujitsu review.
Yes, that would be what this email suggests.
And so if matters like this had been drawn to your attention, this was a small sum of money, but revealed a principal issue of concern, would you have treated the other revelations in the similar way?
I would hope so, yes.
Can we look on thirdly then, please, at poll 307-0126? This is a telephone attendance note of the on Mandy Talbot by SJD3, who's Mr. Dilly, and you. Can you see that?
Yes.
MT Mandy Talbot saying that today's news about problems with the Horizon system at the Falkirk branch had come as a bolt from the blue, that she'd known nothing about it, and that Fujitsu did not give any indication. Could we get Fujitsu a witness to give evidence? Richard Morgan saying we need a Fujitsu witness to identify what this problem was. Why this was a problem, but Lee Castleton's was not. Was there a latent defect or a software problem from a subsequent update, or a hardware problem specific to that branch? Richard Morgan saying he was concerned about whether we have to give disclosure of this fact. He thought probably yes, but wanted to find out if the judge thought it was relevant. Richard Morgan was prepared to put off a decision on this until after his opening. Richard Morgan asked Mandy Talbot to get some definitive answers from Fujitsu. Richard Morgan saying we may finish in court by lunchtime tomorrow. You're recorded as saying that you needed a Fujitsu witness identifying why this was a problem, but that Mr. Castleton's was not.
Yes.
Did you assume that the problem did not afflict Mr. Castleton's branch?
That's a very simple question with quite a complicated answer. I made no assumptions about what was going on at Mr. Castleton's branch. I made no assumptions about what was going on at any other branch. By this stage, I was, I think the case had started on the, was it the 4th, and this is the 6th, so this is the Wednesday. I can't quite remember. So the trial had started. I was open.
No, I don't think that chronology is exactly right.
Isn't it? I can't remember. But the issues were the account stated point, and Mr. Castleton's case was that it was called the Horizon system was causing problems, but he didn't say how or why. I didn't know what the issue was with what's the name of the branch? The Falkirk branch.
Falkirk, yes.
I wanted to know what was going on. Mr. Castleton was wanting to call some other sub-postmasters about issues that were going on in their branches. And the question whether it was relevant to the Castleton trial that other sub-postmasters had problems, and if so, what those problems were. As I recall it, and this is reconstructed from what is said, or what appears in the transcripts and the notes of the hearing that were provided to me, the judge ruled on that and said that although the witness evidence was admissible to show that there were errors or there were problems that had occurred in other branches, there wasn't going to be a trial of the other issues within the Castleton trial. So it all happened in a very compressed time frame, as far as I can recall. And there was a ruling on the admissibility or relevance of issues in other branches that meant this went back onto the back burner. That's my recollection.
So just on the chronology,
Yes,
this is
thanks.
this is the morning of the opening.
Yeah, thanks.
The
The
trial
case-
opened on Wednesday, the 6th of December.
Yes, I think there were two pre-reading days, I think. I thought the first day of the trial was Monday the 4th.
Let's put it a different way. I think we can agree that this was the day on which you opened the case.
Fine, thank you. Yeah, sorry, I don't wish to argue with you, that's just my recollection.
And the judgments that you're referring to, I think if we look at poll 302, 1678, this is a copy of the judgment,
Yes.
and
Yes, this reminds me of this is where I've reconstructed what happened from. I can't remember the precise order. Again, if we had the benefit of the transcripts, we'd see exactly what had happened.
And I think if you turn to page 8, please, and look at paragraph 22. During the hearing, Mr. Castleton sought to adduce evidence of other complaints from sub-postmasters of other post offices about the Horizon system. I admitted the fact that there were a few such complaints, but I refused to admit evidence of the facts underlying such complaints.
Yes.
Since that would have involved a trial within a trial.
Yes.
And essentially, was that your submission on behalf of the post office?
Again, I'm afraid I genuinely can't remember. I suspect it may have been, though. I think
Is it permissible to say that there had been a few complaints, but what those complaints were or the facts of them underlying them was not admissible?
I'm not sure that I would have put it exactly like that, but that's the way it's recorded.
In the event, did you give disclosure of the facts concerning the Callender Square or Falkirk bug?
I don't recall giving disclosure. Sorry. I don't recall my solicitors giving disclosure as the accurate answer.
Thank you. Yes, that can come down, thank you. Can we turn, please, to the way that the case was put on accounts stated and settled accounts? And just go back to paragraph 27 of your witness statement, please, on page 8. You say in the second line, I recall there was a line of authorities in relation to accounts stated and settled accounts. I realised that there was authority for the argument that if Mr. Castleton was tendering his own figures to the post office, he was vouching their accuracy. I therefore advise we should realign our pleaded case to take this point, and we should try and establish the true trading position by reference to Mr. Castleton's own documents. And then paragraph 92, please, on page 31 of the witness statement. You've been asked whether there are any other matters you would like to bring to the attention of the chair. And you say you've seen various books, articles and comments that make reference to the post office and Castleton case. The general assumption in these materials seems to be that in some way the operation of the Horizon IT system was an issue in the case that led to judgment being given in favour of the post office. However, a review of the pleadings, the witness statements and the judgment should provide enough information to confirm that the case in fact turned on Mr. Castleton's own signed books, records and accounts produced by him as the agent of the post office. And that matches what Mr. Dilly told us repeatedly yesterday. He said the post office succeeded in its claim in spite of the computer system. It succeeded in its claim on the basis of physical accounting records. Can we just look at the pleadings, please? Starting with LCAS 40190. This is the re-amended reply and defence to counterclaim. And we can see if we go to page 3 and scroll down. It's settled by you. Can you see
Yes.
that? And if we go back to page 1, please, and look at paragraph 3. It's pleaded, with respect to paragraphs 5 and 6 of the defence, Fujitsu Services have looked at the claimant's computer system and have confirmed that the losses recorded by the defendant were caused by a difference between the physical transactions that actually occurred and were recorded on the system by the defendant or his assistant as taking place, and the cash in hand that was declared by the defendant relating to those transactions. And accordingly, those losses were not caused by the claimant's systems, software, or hardware. We ought to look, I think, at just what paragraphs 5 and 6 of the defence had said. LCAS 40294. And if we go to page 3, paragraphs 5 and 6, Mr. Castleton had pleaded the defendant repeatedly sought assistance from his managers within the claimant company during the period over which the apparent shortfalls accumulated. No assistance was forthcoming. The defendant avers that any apparent shortfall is entirely the product of problems with the Horizon computer system and accounting system used by the claimant. The defendant further avers that he will be able to demonstrate through a manual reconciliation of the figures contained with the daily balance snapshot documents created by the defendant during the course of his tenure as sub-postmaster at Marine Drive Post Office, which were removed from the post office on the defendant's suspension, that the apparent shortfalls are in fact nothing more than accounting errors arising from the operation of the Horizon system. And so Mr. Castleton's case was that the shortfalls were entirely a product of the Horizon system, yes?
That's what he says.
And in the reply in defence to counterclaim, you pleaded that that was denied, that the losses were not caused by the claimant's system, software or hardware.
Yes.
Can you help us on what material that was based?
My instructions.
And where were those obstructions obtained from?
My instructing solicitors.
By what means?
Well, at this distance in time, I can't recall. But
you recall what was pleaded, that Fujitsu had, we better get the wording exactly right.
yes,
LCAS 40190. And paragraph 3. Fujitsu Services have looked at the claimant's computer system, etc.
yes.
Again, and appreciating the distance of time, can you recall anything more than that was based on my instructions, which came from my solicitor?
No.
Can we look, please, at poll 306 9801? And if we look at the foot of the page, just scroll up a little bit, just a tiny bit more. There's an email to from you to Mr. Dilly of the 8th of November.
Yes.
And then if you scroll up to the top of the page, you'll see he says, I thought it would be easiest, solicitors often say this, to reply in blue below next to your original email.
And of course, we have the benefit of a black and white copy.
Exactly so. So it is doubtless easiest for them. If we scroll down, please. I think we can see from the typescript where you're speaking and he's replying.
Yes, I think my points end with question marks, and then the text after that is
Exactly. And I think in the original they would be blue.
Yes.
At what time of day was Castleton suspended? Who arranged for the temporary sub-postmaster to take over? Scroll down, please. Was the sub-post office shut? When was the P242 signed? Did the branch trade? Etc., etc. There's a very wide range of issues upon which you're seeking instructions there, but not the one that I'm asking about.
Yes.
Again, can you recall how that information had been provided?
No.
Namely that Fujitsu had examined the system.
No.
In any event, quite aside from the nice legal point, the reliability of the product of Horizon at least this branch was an issue, or potentially an issue, in the trial.
Potentially an issue, yes. Although if you go back to the defence, you'll have seen that the averment was that Mr. Castleton would be able to establish from the primary figures
Yes.
that they were artificial errors rather than artificial deficiencies rather than real deficiencies. So his case was based upon the written figures rather than the product of Horizon.
But in any event, would you agree that disclosure had to be given by the Post Office in relation to the question of, if it possessed such documents, whether such losses were caused by Horizon, irrespective of your legal point?
One would have to look very carefully at the scope of the disclosure obligation and the information that was being sought. Now, at this stage, Mr. Castleton was represented by solicitors, and they no doubt explored disclosure issues with my instructing solicitors, but disclosure was not an issue with which I was involved or upon which I was instructed, as far as I remember anyway.
Can we lastly, on this subtopic, look please at LCAS 40197? This is a typed copy of a recording of, amongst other things, I think your opening of the case on the 6th of December 2006. And if we could turn please to pages 14 and then 15, please, starting at 14.
Do we know who the author of this document was?
I believe from the designation, it's Mr. Castleton's solicitors, i.e. LCAS, means Lee Castleton. So the unique reference number I called out. But I can check that if we take a break, or when we take a break in the afternoon. Are you quizzical?
Well, I just didn't understand Mr. Castleton to have solicitors instructed, and it's normally...
No, now.
Oh, right.
He's got solicitors in this inquiry who have obtained a copy of the recording and have had it transcribed.
I see. Not by an official transcriber, though.
Is there a point on that?
No, it's just normally I would trust Smith Burnell as being an authorised transcriber, whereas I just don't know what this document... I have no idea. It's just a piece of paper that purports to record what's stated, and I just wondered what the provenance of the document was, that's all.
Shall we look at the piece of paper?
By all means.
Page 14. In fact, to give you some context, we should start at 13. And just under I'm grateful 2338, you are...
Sorry, I'm not sure I'm there.
Yeah, so 7,
I've got it.
8
Yes, I've got
boxes
it.
down.
I've got it. Thank you.
Yeah. You're recorded as saying no, of course. For the assistant, perhaps, of Mr. Castleton, what I was trying to do for the court is, the judge said, is give me background. A very general background, as a gentler introduction at this stage as I can. Then I propose to address your lordship very briefly on one point of view that arises on the burden of proof. Judge, yes. And then even if I'm right on that issue of burden of proof, it might be of assistance to the court and Mr. Castleton if I complete a comprehensive opening so that the court has presented to it in as neutral a way as possible? Answer, yes. The primary documents, yes, there will come a point at which I'll make some submissions as to my primary case, but I hope that will be of help to Mr. Castleton to relieve him of any burdening of opening the case. Yes, quite, and also provide a balanced view of the primary documents before I make some submissions as to why we're bound to win. Otherwise, I wouldn't be here, but hopefully that's of assistance to Mr. Castleton. And then over the page, Judge says the biggest issue in this case seems to be whether the computer is working properly, isn't it? And you say, well, that's how Mr. Castleton would like to portray it. Judge said, yes. You say it's a matter that your lordship may have to consider. Yes, but I'd invite your lordship to listen to my opening and understand. The facts, much like a pocket calculator, a computer is only a tool that reflects the information that's entered onto it. And the way the system is meant to work is that Mr. Castleton is meant to check the underlying physical transactions against what's shown on the printout. He says, I see, I'll leave it to you to explain that in due course. And then you say, and your lordship in fact touches the core of this question, the core of this trial, and that this is about a trial about an account product produced by an agent, which is verified by him, or is this a trial which is a rampage through how a computer system works, and whether this is whether Mr. Castleton can say that the computer has anything to do with this trial at all. Judge, when you say it's an account, and there's an unclear passage, which it may well be, but it's still open to Mr. Castleton to say that the account is wrong. You say it's still open to Mr. Castleton to say the account is wrong in certain limited respects. Judge, if the computer's wrong, if it can be shown that the computer's wrong, you say if he could show, just go back please. If he could show the computer were wrong, yes. You say in my respectful submission he could only do that by producing physical evidence as to why it's wrong, and that's going to be the nub of the dispute. And so this is the first time that we see the strategy of relying upon the vouchsafing of the physical cash account being deployed at the trial, I think.
Being deployed at the trial, yes.
Yes.
It was deployed in the amended statement, particulars of claim.
Yes, yes. I meant orally
Yes.
at opening. And so was the trial about whether the Horizon produced documents included accurate cash accounts?
No. Well, not as far as I understood it. The trial, or the claim, was based upon Mr. Castleton's signed statements of account.
And where had those documents all come from?
Mr. Castleton,
No, where had the documents that he signed, where had they come from?
I don't know.
What had produced them? A computer?
Thinking back all of these years, some of them may have been produced by a computer, some of them may have been produced by one of those sort of typing calculators, some of them may have been produced purely in manuscript. I think the lists of amounts of cash by denomination were manuscript.
But the
Documents.
the end of week cash accounts, which
Yes.
was the principal document that you relied upon as the agent's account,
Yes,
they were produced by Horizon, weren't they?
they may well have been, yes.
And they had
Sorry, I'm not trying to be difficult. I genuinely can't remember. I think they were printed documents, and I think they were signed off by Mr. Castleton.
Can we turn to a different subtopic, please, and look at some tactical issues? Can we go back to paragraph 52 of your witness statement, please? Which is on page 16. And scroll down, thank you. You say, I've no idea what the tactical position of the Post Office was in this litigation or what reasoning was behind it. Yes?
Yes.
And you say that you advised explicitly that the costs were going to be out of all proportion to the amount at stake, but you continue to be instructed to progress the matter to trial. And you even advised that a drop hand settlement should be attempted, but that doesn't seem to have been taken up. Yes?
Yes.
And so you had no idea at all of what the Post Office's tactics were in this litigation, why it was continuing to fight it, why it was continuing to spend money on it.
I thought it was commercial madness.
And you use that word.
I might well have done, yes. I
in
tend
an
to be
email.
quite blunt about
Yeah,
my views.
about stopping this madness.
Yes.
I just want to see whether things were revealed to you about why your client was pursuing this madness. Poll 306-9490. This is a telephone attendance note of a conversation between Mr. Dilly and you on the 10th of October 2006.
Yes.
If you just read the first three paragraphs to yourself to get some context rather than diving straight in.
Yes.
And in the fourth paragraph, it records that you thought, quote, we should play some brinkmanship and press for a December trial if they disclose an expert's report that harms us, as they're going to be so late. We can always ask the court to vacate the trial. However, at the moment, they've not disclosed an expert report, and he thinks we can go to trial without one. However, he wants us to get client approval for this strategy. On the issue of brinkmanship, what do you understand you two have meant in this context?
Yeah, so this was a question that was posed to me at the outset, and I have thought about it. I don't have a direct recollection now of what was being said, but I can reconstruct what I would have been thinking if that would be of help.
Yes, please.
So you have what is by High Court standards, a tiny piece of commercial litigation going to trial. You have some generalised allegations that haven't been particularised, and you have some directions for exchange of evidence and exchange of expert evidence. It is quite clear that the longer this case drags on, the more of a gaping wound the costs are going to become. They're already wholly disproportionate to the amount at stake, and something has got to force the issue that will either result in the case becoming clear, the expert evidence articulating what it is that the defendant is pointing at, or it needs to go to trial. What you can't do is just let it roll on and on and on. So press for the December trial, see if that provokes the service of the evidence that's going to be used by way of defence. If it does actually provide a defence, then we might need to seek an adjournment. If it doesn't, then you just go to trial.
Thank you. Can we turn forward to poll 307-2432? This is an attendance note on the 16th of October, so 6 days after the conversation we've just looked at. It's not an attendance note upon you. It's Mr. Dilly on Mandy Talbot.
Yes.
And if you just read the first couple of paragraphs to yourself to get some context. And then if we look at paragraph 3, council was much happier with the case now. We had all these witness statements and in fact thought they were thorough and we really didn't need expert evidence. Council therefore wants to play some brinkmanship with the other side, i.e. push for a December trial but preserving our ability to get that adjourned if they serve a late report we need to deal with. I said we could prepare for a December trial if necessary, and I was happy to do so, but I was concerned to make sure that we would reply to any expert report served by Mr. Castleton. I also thought that our counsel was effectively trying to ambush the other side because he thinks that when we serve these 15 witness statements on them, they will be knocked reeling a bit. Mandy appreciates the tactics of this. She said the only thing was a December trial is that the post office gets very busy before Christmas generally. She'll speak to her colleagues and come back to me on council's tactical ideas. And there's a subsequent email, subsequent telephone attendance note saying that the post office are happy enough to follow council advice and go for the December trial purely as a tactic. And that's poll 3069453. The type of brinkmanship spoken of here is of a slightly different flavour, isn't it? Was it part of your strategy to ambush Mr. Castleton?
No, not at all. We'd had a CMC, I think, in September or October of this year.
That year,
Of that
it was
year.
a pre-trial review, not a CMC.
I'm grateful. Where Mr. Castleton was represented by counsel, and we had both said that this case was not suitable for the High Court. And we had invited the Master to adjourn it off to Central London County Court. And the Master had declined to do that. He wanted to hold it to a trial date in October to December of 2006. So it was a court-driven direction for a hearing, and the hearing had been fixed, and there had been directions down to the hearing. It's hardly an ambush when everybody's been told about it by the Master giving the directions. And I felt we should hold it because otherwise not only were we going to be staying in the High Court and not getting the advantage of the earlier hearing date that the Master was keen to achieve when he kept us in the High Court, but we wouldn't be getting the evidence that he'd directed be served. So I don't think, with respect to Mr. Dilly, I don't think he's correct to describe it as an ambush.
Thank you. Can we move, please, to page 15 of your witness statement at paragraph 49? So page 15, please. And paragraph 49. You say, I've absolutely no idea why or by whom the Castleton case was considered a test case, although I note Mandy Talbot apparently said it had, quote, almost become a test case in spite of itself in an attendance note of the 11th of September 2006. As far as I was concerned, it was a single case to be decided on its own facts, as with every other case. I didn't adjust the issues to run it as a test case, nor was I asked to run it as a test case for anything. I was only ever instructed to bring a claim to recover amounts owing. The case wasn't presented to the court as a test case, and in my view, the judgment doesn't read as if the judge treated it as a test case of anything. And so, reading that together, it was your view that this was not a test case in any sense of that word, or those words, for the Post Office?
Yes, it was a single one-off case.
Can we look, please, at poll 3069622, which is the attendance note you refer to there? This is a 6-page attendance note of a conference held with you, 2 solicitors from Bond Pierce, and a number of the witnesses that the Post Office was going to use at Mr. Castleton's trial.
Yes.
It's at your chambers. And if we just go to page 5, please. and look at the end of the document. Thank you. Meeting with Mandy Talbot. Tom, that's Tom Beezer, I think, explained that the big issue in this case was proving the loss. Horizon is like a big calculator, and it can be changed after the event. Tom went on to explain why. Just thinking back to the answer you gave about the issue of whether you got an answer to the reasonable question you asked, can the system be changed after the event? Presumably you don't now recall receiving this explanation, nor indeed what the explanation was.
No.
And again, thinking back, do you think this played any part in the strategy of deploying a nice legal point? That
No,
there were actual real difficulties on the ground in proving a loss?
I don't think I do recall this playing any part, because I just think the sequencing is wrong. I think I'd already taken the decision by that stage that it needed to be by way of settled account or account stated. I thought, look, it's such a long time ago, but my feeling at this remove is that that decision, or my advice, was given in August, and that it then sort of rolled forward.
At the foot of the page, Mandy Talbot said the difficulty is this has almost become a test case in spite of itself. The Post Office, other solicitors' cases are waiting and watching on this. And then it can turns to consider settlement. Did you know of any reason why Mr. Castleton's case might be singled out as a test case instead of other cases involving allegations that there were issues with the Horizon system?
I don't remember knowing any at the time, no. I don't know any now, and I don't remember knowing any at the time.
Would you expect a client who viewed their case to be a test case to ordinarily inform you of that fact so that you would have knowledge of it when conducting the litigation?
In my professional experience, the only occasion on which a client has told me that a case is a test case is when it's been a government department. And government departments then ask for particular arguments to be run in particular ways so as to achieve a result that is useful for other cases. And I have not been lead counsel instructed on those cases. I've been acting as junior to the Treasury Devil. So I've seen it happen. I've seen it happen for government departments. I've never experienced it for a commercial client, and the considerations are rather different.
Do you now recall what you made of being given this information?
Given what information?
What's recorded at the foot of the page?
No. Should I?
What effect would that information have on you?
Well, I don't think it would have any effect at all, because I don't think there was anything I could do. I had a case. My obligation was to run it to the best of my ability in accordance with my instructions. But my instructions weren't run it in this way so that we get a precedent to achieve X or Y or Z. My instructions were there is a debt of £25,500 odd pounds owing by Mr. Castleton on the basis of what's shown for his branch. Please take the claim to trial. It wasn't. A government department would say, please take the case to trial and achieve this result on the basis of these arguments. That was my discretion as to how the case was put at trial. Was never circumscribed.
I see. So you weren't given instructions to try and establish a legal point?
Yes, that's right.
And you weren't given instructions to try and establish the integrity of the Horizon system, either A, insofar as it works in the Marine Drive branch, or more generally?
Exactly. And indeed, had I been asked to do that, I think I would have given them a pretty succinct answer as to why I wasn't going to do that and how I couldn't do that, particularly not on the basis of the evidence that I had.
Well, also, such an approach would be inconsistent with your primary strategy of proving the case on the account.
Yes.
And so I'm asking you, what became of this? You've got somebody saying to you here, an important person within the post office, this has become a test case.
Well, she does not. Sorry.
Or, okay,
There was a conversation in a conference in September of 2006 at which Mandy Talbot was present. Mr. Lister or Mr. Beezer or whoever it was took an attendance note and recorded something that may or may not have been said within that conference. I don't remember her using those words, but there again, I don't really remember the meeting at all. And almost become a test case in spite of itself. If those were the words used by Mandy Talbot, they don't. If I was cross-examining, I wouldn't be putting it to the witness that Mandy Talbot was saying that it should be run as a test case. It's more of an observation by an individual as to what she thought was happening to the case. But there we are. I mean, I just can't assist you as to what she thought she was saying, why somebody's seen fit to take a note of it, or what it means. But it certainly didn't impact upon what I was doing.
Can we therefore look to some other documents to see whether they provide some help?
Of course.
Poll 3072741. This is an attendance note of a telephone conference between you, Tom Beezer, Stephen Dilly and Adrian Bratt on the 16th of August 2006. You discussed the pleadings on page 1. And if we go over to page 2...
Hang on, sorry, can we just... Yeah, so you can see here that we're already discussing pleading it as an account by an agent.
Yes?
Yes.
If we look at the foot of... if we go over to page 2, please. You discussed the defence, and then the discussion ranges a bit more broadly than that if we go to the foot of that page. You're recording as saying, I think this is 2 paragraphs from the bottom, this would be better off in the Chancery/commercial list of Central London County Court. We should write to the other side and explain issues of proportionate use of High Court time and effectively use our letter as a shield to the judge. Mr. Dilly, this would have settled without the computer/Horizon issue and the subsequent sub-postmasters bloggers website.
Yes.
What did you understand, or what do you understand that to refer to? The case would have settled but for the computer/Horizon issue.
That Mr. Dilly thought there was something that was stopping the case settling, and that, well, in interpreting it now, that Mr. Castleton was being led to believe that his losses were illusory by the fact that other people were saying that there was something going on.
Was there any suggestion made to you at this time that it was important to the Post Office to vindicate the reputation of Horizon?
No. And as I've just been saying, that didn't form part of my strategy, nor was it communicated to me, nor could I have run it had I been told to do it on the basis of the material that I had.
Can we look, please, at poll 3069794? This is a telephone attendance note of a conversation with you on the 9th of November 2006, made by Mr. Dilly, and the conversation with Mr. Dilly. If we can look, please, at the second paragraph from the bottom. I said, that's Mr. Dilly, I said that ultimately the post office driver had been getting a judgment against Mr. Castleton to show that the computer system wasn't wrong and deter other sub-postmasters from bringing a claim. I therefore thought the most important thing for them was getting judgment for the full amount. We wanted as much cost recovery as possible. But given I previously told the post office that Castleton's asset position was unclear, I think if there's going to be any movement at all in our negotiating position, it's going to be on costs. So what this note records you as having been told a month or so out from trial was that the driver for the post office had been to get a judgment against Mr. Castleton to show its computer system wasn't wrong and to deter other sub-postmasters from bringing a claim. That's not about recovering the money, is it?
No, I agree.
It wasn't about the sums involved in either the claim or the counterclaim.
Yeah, I can see that.
And you were being told, according to this note, it was to get a judgment to show the integrity of a computer system and about deterrence.
Yeah, I can see that.
Had that been expressed to you previously? I mean, looking back at some of the things that we have earlier looked at, the earlier attendance notes, when you were saying it's madness to continue to litigate this claim, and they said, no, it's important for us to continue it. Do you think, thinking back, that that's what they regarded this case as about, the post office?
I genuinely don't think so. I mean, I hadn't focused on this at all, and it certainly hadn't formed any part of my thought process in preparing for this hearing. I didn't recall this as being information conveyed to me. I'm quite surprised to see it there now. I don't recall it at the time. And had I focused on that, I think my response would have been that I simply couldn't prove that the system wasn't wrong. It just wasn't an achievable objective.
Can we look next then at poll 3069775? You'll see from page 1, you're copied into this email chain here.
Yes.
And if we start at the back of the chain, please, on page 3. If you just look slightly above that, please, Frankie. You'll see that the chain starts off with something you're not copied in on, an email from Mandy Talbot to a range of people within the post office and to Mr. Dilly. 10th of November 2006, solicitors have substantially accepted our counteroffer. Castleton not prepared to have judgment against him. Scroll down, please. Castleton is prepared to make an open statement that the post office can use as it chooses, make an open statement that the post office can use as it chooses, exonerating the Horizon system. I now seek your assistance. And then, skipping a paragraph, I, Mr. L. Castleton, admit that a sum of money was owed by me to the Post Office Limited as a result of errors which arose whilst I was the postmaster at the above office. I had thought that this debt arose due to a malfunction in the Horizon system, but I now accept that I was mistaken and that the debt arose out of human error. I declare the Horizon system did not contribute to the errors in any way and formally withdraw all statements I made to the contrary. And scrolling up, please. Mr. Baines, on the same day, says, Mandy, I think the draft says all that it needs to. Few minor changes. Revised text as follows. I, Lee Castleton, admit that a sum of money was owed by me to Post Office as a result of errors which arose whilst I was the postmaster at the above office. I had thought that this debt arose due to a malfunction of the Horizon system, but I now accept that I was mistaken and that the debt arose out of human error. I declare that the Horizon system did not contribute to the errors in any way and formally withdraw all statements I made to the contrary. And then scrolling up still further, we can see Mr. Dilly's proposed suggestion. He says, one, I don't think Mr. Castleton will want quite as plainly to admit owing the Post Office money. We can try to get him to say that if you want, but I doubt he will. I wonder if you can change to, I, Lee Castleton, fully and unreservedly withdraw the untrue allegations I made about the operation of the Horizon system. Previously, I thought that discrepancies that arose at the Marine Drive Post Office whilst I was sub-postmaster arose due to a malfunction of the Horizon system, but I now accept I was mistaken and that the discrepancies were caused by human error. I declare that the Horizon system did not cause or contribute to the discrepancies in any way, and I formally withdraw all statements I made to the contrary and undertake not to repeat them and or make any further allegations about the Horizon system and or its functioning. And you were sent that. I can't see any trace of you having replied to that or offered a view on any of the three formulations of the statement that it was proposed should come from the mouth of Mr. Castleton. Would you agree that this discloses Post Office motivation, an important motivation being to get a publicly declared clean bill of health out of the settlement?
Well, I can see what you're arguing, but I had no input.
I'm sorry, you can see what I'm
arguing, but
I'm not arguing anything, I'm asking questions.
I can see what it says. I can't give you evidence what the Post Office's motivations were, but I can see why you're saying that that suggests that what they're doing is to vindicate the Horizon system.
Does this not disclose further evidence that it was revealed to you that they saw this as something as a test case to get a clean bill of health for Horizon?
It discloses to me that they don't want Mr. Castleton to say that the problems were caused by Horizon.
But of course this ran directly contrary to the way that you wanted to run the case, which was Horizon's irrelevant. This has got nothing to do with Horizon.
It ran directly, well, no, it didn't cut across what I was going to argue at all. It made no difference at all to what I was going to argue. As far as I was concerned, I had instructions to run a case based on the amended particulars of claim, and that was what I was going to do. And at this stage, 10th of November, I suspect I was starting to work pretty hard on the primary documents. So, as you'll probably be aware, when one is prepping for a large trial, and even though the amount at stake was small, there was a lot of paperwork that needed to be understood. I was focused on getting on with the trial preparation.
Thank you, sir. Might that be an appropriate moment for the afternoon break? It's 2:00 now.
Oh, can I just ask, sorry, there was just one part of that document I had a question about for Mr. Morgan. Could he go back up just for, it'll only take a minute. You see, Mr. Morgan, the paragraph in quotes, which Mr. Beer was asking you about. In the next paragraph, what's written is as follows. The real question is whether we need the undertaking, which I interpose to say I'm assuming that relates to the paragraph in inverted commas in clause 5 of the schedule. Richard, which I assume is you, thinks that by making a song and dance, we highlight a sensitivity, etc. So it appears as if you were expressing reservations about having that sort of formula in any part of the Tomlin order.
Mr. Chairman, part of the problem with this is that you can see from the top left, there's a draft Tomlin order, 10th November, attached as an attachment. When I was provided with the bundle of supplemental documents, it helpfully has the back sheet for the draft Tomlin order, but not the terms of the order itself. So I haven't been able to refresh my recollection of what...
So are you telling me, Mr. Morgan, that clause 5, I might be assuming that clause 5 relates to the paragraph in inverted commas above, but it may in fact not?
Well, I don't know, because there seems to be an undertaking, and that doesn't seem... Look, I just can't assist because I don't have the document to read to see what's being talked about. And
right.
I'm hesitant to commit myself to something that I haven't read.
I follow. I follow. Right, thank you. Yes, Mr. Beer, we'll have our afternoon break.
So
How are we...
20 past, please.
Yeah, and how are we looking generally for this afternoon?
We're looking good, sir.
Fine. Thank you very much.
Good afternoon, sir. Can you see and hear me?
Yes, I can. Thank you.
So can I start by picking up on a document that may assist both you and Mr. Morgan to answer the questions that you asked him before we took the break, and asked to be displayed poll 308 1826. I can't ask for that to be displayed. Essentially, sir, I'll come back to this in the hope that in the next half an hour, that document is onto the system, but it is the rest of the Tomlin order obtained from a different source. It's amongst documents that the inquiry has recently been provided with, which is why it's not on the display system at the moment. Whilst that's done behind the scenes,
Is paragraph 5 in the same terms as the...
yes and no. So let's look at the document when I can display it. Thank you. You've told us that before you argued the case at trial,
Yes.
you didn't think that this was a test case at all, and it was essentially a case that turned on its own facts.
Yes.
Can we look, please, at poll 307 0020? This is an attendance note of the 22nd of January 2007. And you'll see that it is described as hearing of judgment poll against Post Office Limited against Lee Castleton, an attendance note of Mr. Dilly, and then scroll down a little bit, please. Hearing of judgment Post Office against Lee Castleton. It sets out who's present. And then there's some arguments about costs.
Yes.
Then over the page, please. More arguments about costs. And then scroll down to the penultimate paragraph. Thereafter, returning to Council's chambers and having joint telephone conference with Mandy Talbot to update her on the outcome of the cost submission, she was very pleased. Richard also offering to supply her with a separate note on how she could use the judgment, and advising that under the new procedure, the sub-postmasters don't physically sign off the accounts that they supply every month. She should think about getting them to do this. She explained that is what the legal affairs team in the post office has advised them to do when they changed the system, but they were overridden by business concerns. RM suggesting that they at least electronically sign some certification on the accounts stating that they accept that they are true and accurate and representing a fair position on profit and loss, stock and cash, because if this case ever arose again, then it would make it much easier for the Post Office to rely on the Castleton precedent and get judgment against sub-postmasters and not incur such great costs next time. Was this an offer by you to help the Post Office get maximum value out of this precedent?
Again, it's a very long time after the event, but it's no more than an impression of a recollection, is that after the judgment was given, we had a discussion about whether it was any use. And you sort of see it picked up there. There was some exchange where she told me, or somebody told me, that the post office's whole system had changed and that they were no longer going to have cash accounts, or no longer going to have daily cash accounts and weekly accounts and so on and so forth. And my response was that that meant that Castleton was not going to be of any use unless they had the cash accounts that we'd relied on at trial to achieve the same accounting position. And that was the note that in due course I produced, and I think that's somewhere in the bundles.
Can we look at that, please? It's WBON 5023. If we just scroll to the last page, please. One page up, sorry. That's the back sheet. And then scroll down. We can see that it's an undated advice written by you. You've helpfully told us in your witness statement by explaining that the Chamber's fee system shows that it was sent out on the 22nd of January 2007.
Yes.
So if we go back to the first page, please. You say, following judgment, I've been asked to provide a short written advice on the key points that have emerged from my involvement in the case as a whole and the judgment in particular. I should emphasise the advice has been written as a short preliminary overview and should not be relied upon as providing a final and definitive consideration of all steps that should be taken in order to ensure that the Post Office derives maximum advantage from the judgment. And just stopping there, did you know beforehand that the Post Office wished to derive maximum advantage of the judgment, i.e. before judgment had been handed down?
No, but there again, I didn't even know that we'd won.
I'm sorry?
There again, I didn't even know that we'd won before the judgment was handed down.
No, but were they not telling you that they regarded this as a case that it was an important precedent or that could be seen as a test case,
Not that
and that it was a case in which the Post Office wished to use to deter other postmasters from bringing claims?
Having seen the email that you took me to before the break, I can see that that was one of their objectives. But it wasn't the basis upon which the claim was run. Having won the case, this advice is given in order to provide a steer as to how it might be relied on if the same procedure is followed in the future.
Reading on paragraph 2, please. You say the first point is that it is easier to sue a sub-postmaster on an account produced by him than try to prove that a loss has arisen in the business. Trying to prove such a loss, if it is possible at all, is extremely difficult forensically and will inevitably be expensive and time-consuming. The second point is that the Post Office derives a significant advantage in litigation if the sub-postmaster bears the burden of proof to show that the account sued on by the Post Office, such as the cash account final, is wrong, rather than the Post Office having to prove that the account sued on is right. This reversal of the burden of proof can only occur if the Post Office is suing on the sub-postmaster's own account, i.e. on a formal account produced by the sub-postmaster sued on by the Post Office, such as the cash account final is wrong, rather than the Post Office having to prove the account is right. The reversal of the burden of proof can only occur if the Post Office is suing on the sub-postmaster's own account, i.e. on a formal account produced by the sub-postmaster and tendered by him to the Post Office as his confirmed statement of the trading that has occurred. Then over the page. As such, a cash account final or any other account produced by the sub-postmaster is only likely to be treated as a final account for a given period if it is 1, produced by the sub-postmaster, 2, at least in circumstances where he's contractually required to produce and verify the figures as accurate, but preferably where he formally certifies the figures as such. And 3, where the sub-postmaster physically signs off the accounts as such, alternatively signs electronically. Third and final point is that if and when it's decided that a sub-postmaster is to be suspended or removed from post, he should be required, in accordance with the terms of his contract, to produce and sign a final account of the date of his removal, whether or not the post office has conducted its own audit. The purpose of requiring this is simply to rely on the reversal of burden of proof and remove the necessity, though not the desirability, of having to call the auditors to prove the loss. You say here that sub-postmasters should be required to sign the cash accounts. Was that language reflective, as you understood it, of Pol's, the post office's attitude, as you had come to understand it, that they were happy to impose conditions on a postmaster that may have the effect of, for example here, reversing the burden of proof and thereby obtain a dominant position or a position of power over the sub-postmasters?
No. This is almost a sort of reflection of my chancery background. It's more that the principal-agent relationship entitles the principal to rely on the accounts stated by his agent as being final and definitive, and in order to show that the account is that of the agent, it would be rather sensible to have it signed by the agent. So this note is written as a chancery practitioner giving advice as to the formal situation in which an account stated arises as between an agent and a principal, not a reflection of the position as between a sub-postmaster and the post office, although as reflected in the terms of the contract as then in existence between the post office and sub-postmasters that had been relied on in the Castleton case, that seemed to arise as a matter of necessary implication from what I can remember of the contract, but I haven't reread the contract in the last 17, 18 years.
In relation to this advice, was it based on the assumption that the loss of which the post office complained was a genuine one,
Yes.
and not an artefact of the computer system?
Yes. Again, as somebody practicing my field, I can't conceive of people signing off on documents that aren't true.
What about somebody signing off on documents because they have to continue to do so to trade into the following week, and they phone a helpline dozens and dozens of times and say, these things I'm signing off, they're not correct?
Yes, I mean, that's something that seems to have emerged subsequently in the post office, in the case in front of Mr. Justice Fraser. I mean, I haven't followed that in any great detail, but I can quite understand why people might say that it's signed under duress and so on and so forth. When this matter came back to me on the Rule 9 request, one of the things I did was go back and look and see whether Mr. Castleton had himself given any indication that the figures he'd signed off were inaccurate, or that he'd signed off on them because he was under some duress or there was some other reason. And I didn't at the time, and I still don't get any hint of that in the pleadings or the evidence. But, I mean, there are all sorts of reasons why figures might be wrong, or so on and so forth. But at no stage during the trial, so far as I can recall, did Mr. Castleton say that his figures were wrong. Had he done so, the consequence would have been that the trial would have been adjourned, the matter would have been remitted to a master for an account to be taken, and we would have gone through the same process and established what the actual loss was by reference to amounts by way of cash and goods within the business, what had been taken out, what had been paid in, what had been transferred out, what had been transferred in. There had been a process of verification of the account. on the old account stated procedure. So we would have got to an answer. It might not have been the same answer, but the whole process of the amended particulars of claim was to establish what the actual real loss was.
Just on that point,
Yes.
I'll come back to the note in a moment. Can we look, please, at LCAS 40197? This is a transcription of the recording of the opening again.
Yes.
Can we just go to page 11, please? And look at the foot of the page. Thank you. You're, in this part of the opening, Mr. Morgan, taking the judge through some weekend balances and doing it week by week, referring to accounting periods, and you've dealt with 52. And the judge asks, second box from the bottom, I see, I don't quite know what a trial balance is. Do I need to know that? You say, well, my lord, if I may, I'll bring your lordship back to the delights of the Post Office accounting system, as I hope I make my opening more coherent. I'm afraid it's quite a technical trial in looking at how these figures are made up. And not that your lordship needs any reinforcement, but it's taken me some number of weeks to work out how all the figures go backwards and forwards. But I hope I'll be able to give your lordship a rational and relatively simple explanation. Of course, Mr. Castleton is the expert, and we'll be hearing from in due course. Mr. Castleton, could I, my lord? The judge says yes. Mr. Castleton, my lord, sorry, throughout this period, the actual trial balance, I'll be the final balance for this week, is actually produced on a Wednesday evening. And at this point is when the sub-postmaster is allowed to address any issues throughout the week's trading. If there are any shortfalls, then he's able to ring a helpline that's run by the Post Office in order to explain any problems that he's had over the former week, any balancing problems that have occurred prior to the Thursday morning. And you'll see that all those cash accounts are actually timed and dated on the following morning, which is a Thursday, I see, because you'll find that all of those losses have had phone calls and assurances from the Post Office themselves that they would look into the reason as to why those losses were occurring. Yes, so they were all reported. Yes, and then it stops. That appears to be Mr. Castleton in the course of the opening, saying that although the weekends were the weekend accounts
Yes.
were signed off, all of the losses had phone calls made to the helpline with assurances from the Post Office that they would look into the reason why the losses were occurring. And then in evidence, poll 306 9279 this is a transcript of Mr. Castleton's evidence. And can we look at page 37, please? And look at E. This is you cross-examining Mr. Castleton still. You asked, do you also accept that when you produced the document at 2979, that was a draft report produced so as to enable you to check the figures before you put them into the final cash account? No, because inaudible final cash account. I'm sorry, but that's not the case. The cash account generates itself. It's generated from the transaction something Chesterfield. If you take up that bundle 6B, you say, and he replies, yes. You say, I suggest that in fact the cash account is generated by your machine at Marine Drive branch. It's not generated by Chesterfield. Answer, if you look at blank witness statement, you'll find that the series of checks that the computer does through Marine Drive Post Office branch through Chesterfield corresponds. It's not generated in-house. And you'll also find me checking these figures now, that to check is not a generated or figure that we actually place into the computer. It is a check has been done daily on separate information that the computer then reproduces in the cash account. Then scrolling down, again at E, you ask, did the cash accounts correspond to the physical evidence of the transactions you had undertaken? Answer, no, not always. We need to differentiate between cash account and the daily transaction on the logs, and also the stock figures produced by balance snapshots. And then over the page, please. At C, so you check all the figures in the final balance against fiscal records, yes, and only when you're happy with that do you proceed to print out cash account final. Answer, and if there's anything I don't agree with, I make a phone call to a helpline, which is what we repeatedly did. So thinking back, given the intervention in the opening and the evidence that was given there, wasn't it the case that Mr. Castleton was saying, yes, I signed the accounts that were produced for me by the Horizon system, not within my branch. I was signing that there was a discrepancy, a shortfall between the cash and the stock which the system said I should have, and the cash and stock which I in fact had, and I was reporting that at the time. It's not something that's only emerged years later, is it?
Well, my impression of his evidence, and that may be a false impression, and it's the impression that the judge formed, and it's the impression that one gets from reading the defence as well, is that the figures that were signed off by him were what was actually present, and that were a fair and true reflection of what had occurred.
He was signing off that there was a discrepancy, that there was a shortfall,
Yes.
and contemporaneously reporting that it wasn't his responsibility. He was reporting that back to the post office, wasn't he? That's what he was saying.
But there was a discrepancy between what he'd got and what he ought to have,
Yes.
and that's what a loss is.
Even if it was generated by Horizon.
Well, that may be where we differ, because at the end of the day, what he actually has and the business that he's done, if there's a discrepancy between that and what he ought to have, then that's a shortfall.
Even if one of those is produced by a computer, which he says is faulty.
Well, I'm sorry, hang on. I'm not quite sure what you say is the bit that's faulty.
A document that I'm signing which says I should have this amount of cash and stock, £1,000, I've in fact got £500 of cash and stock. I'll sign that to say the system says I should have £1,000, I've in fact got £500. Sign that, true and accurate. Get on the phone and say the bit of the account which says I should have £1,000 is wrong. It's been created in the following ways. I mean, I'm not going to go through all of Mr. Castleton's calls to the helpline,
No.
where he repeatedly explained to them on the day that the event happened why the system was creating phantom figures. But that was his case, wasn't it? It wasn't only something that emerged years later before Mr. Justice Fraser. And it may be that it wasn't very well articulated by Mr. Castleton, being a litigant in person. But showing you the two things that I have, the opening and the evidence and the point were there, weren't they?
I didn't understand them to be there in that way at the time, nor did I understand them to be there on the basis of paragraph 3 of the amended defence and counterclaim at LCAS 000294. 40294.
Lastly, can I ask you some questions on a discrete topic, namely the treatment of Anne Chambers and Mr. Jenkins? Please, can we look at poll 307-1438? This is an attendance note made by Mr. Dilly in respect of a conversation with you on the 11th of August 2006, and it concerns the draft witness statements of Anne Chambers and Gareth Jenkins. If you just read the first couple of paragraphs to orientate yourself. And then look at the third paragraph. In relation to Gareth Jenkins' statement, we need to firstly say he holds a position with the job title of a distinguished engineer. It might be that we decide to put all the information he is saying into the expert's report, given it's really opinion evidence. So you've been provided with these two draft witness statements from Fujitsu employees. The advice that you're recorded as having given there, would that reflect your view that to the extent that Mr. Jenkins' witness statement contained opinion evidence, that couldn't be given by him, it had to be given by an independent expert?
If it was truly opinion evidence, yes.
And why would opinion evidence have to be given by an independent expert rather than Mr. Jenkins?
Well, technically, anybody can give any evidence they want in a civil trial, but ordinarily it would be excluded if it was opinion evidence, unless it was given by an expert who is able to give an independent expert view.
And why couldn't Mr. Jenkins give an expert view?
Because he's not an independent expert.
The decision was taken in the event not to call Mr. Jenkins. Did you hold a view on whether Anne Chambers was giving, according to her draft statement, opinion evidence or evidence of fact?
At this distance in time, I can't even remember what she was saying.
Thank you very much. I understand.
Thank you.
So those are the only questions that I ask. I understand that there are two call participants who wish to ask questions. First, Mr. Steen.
Right.
Mr. Morgan, my name is Sam Steen. I ask questions on behalf of a very large group of sub-postmasters and mistresses. Can I take you within your statement, please, to page 30? And if we can have that on the screen, please. I refer to page 30 of Mr. Morgan's statement, paragraph E to start off with. Thank you. Mr. Morgan, you've been asked some questions about this part of your statement, which is in reference to the 12th of June of 2012, where you had a short consultation and you refer to it there as being the matter is simply entitled Post Office.
Yes.
Now, you've been asked some questions about that. So moving on from 2012 to 20th of March 2014, now, at this point in your statement, you say this, that you were contacted by Linklaters to advise Post Office Limited. And your records are showing 3 short telecons, and you think, although you might be mistaken, that you also had a short in-person consultation with Krista Band of Linklaters and Paula Venables of Pol. At that time, Paula Venables of Pol was the Chief Executive Officer. Is that right?
Part of my difficulty with this is that I'm not sure that this is a true memory. I mean, what I've tried to do is I've tried to give as full and accurate an account as I can, but then say, I actually don't think this is a true memory. The problem is I've seen Paula Venables on TV, and I feel that I was meant to meet her, but I just can't find any record of actually meeting her. And I'm sure, given the way my clerks like to make sure that everything is recorded, that if there had been a meeting, I would have had it in there. But since I had some sort of feeling about it, I thought I should describe it.
Right. Well, let's see what you were able to get to. your statement does say that you also had a short in-person consultation with Krista Band and Paula Venables, which appears to be a bit more than a vague daydream of a meeting, doesn't it?
Well, I don't know. What I've said is that I think, although I might well be mistaken, that I also had a short in-person consultation.
Okay.
And then what I'd also say is, but I've got no record of it. I've got no record of a room booking. I've got no record of a fee line. I would have made a fee line for it if I'd met somebody and given them advice.
Okay. Let's just move on to the remaining bits of F. You have it at page 30. You go on to say, and you're emphasising really that you don't have a great recollection of this. You say, I have no specific recollection of what was happening. Beyond thinking that I was asked, what could Paul do about any arguments being raised in relation to the accuracy of the Horizon system? To which your answer was that they should follow the advice you had given in 2007 and keep a physical paper trail of accounts signed by the sub-postmaster. And then you go on to talk about the fact, jumping then a little bit, I should emphasise that this memory of a meeting and the identity of the participants may be a false memory, possibly something I've reconstructed, having been told there would have been or would be a meeting. Okay?
Yes.
And you again emphasise after that, I'm not really sure that a physical meeting ever took place. Again, a reference to the fee line. So
Yes.
what we do know is this, as far as we can tell, that there's some contact to you in 2014, March of 2014, and as best as you're able to, this was a meeting that wasn't terribly memorable, because you're saying, well, best I can do is that if they want anything from me, they should look back at my earlier advice in 2007.
Can I try and give the evidence?
Any way you like.
So it's something I keep on going over in my mind as to whether it took place or not. The phone calls definitely did take place. I think the first was, did I remember what the post office case was? And the second or third one was, what we'd like to talk about is how one goes about tidying this up or not. I don't even know whether it was tidying it up. It's just, and my entire point was the one case that I did that actually involved the Horizon system relied upon physical accounts, a physical paper trail signed off by the sub-postmaster. And that is the core of what I was saying. In fact, that was probably all I was saying. I didn't receive any papers, I didn't receive any instructions. It was, would like to talk to you about Horizon. Do you still keep physical paper trail of accounts signed by the sub-postmaster? Because that's what I'd suggest you do.
Right. So we start with the date.
Yep.
There's a reference to that in March 2014. So working on that as being at least some contact to you, what I'm going to ask is, and see if I can find out whether particular points may have been raised with you that actually might stand out, might
Sure.
be quite important. I'm going to take you to a document which I provided to our document provider, and it is POL, P-O-L, 406798. And frankly, if you can go to page 13, internal pagination in the document, page 13. Now, this document is written by a barrister called Simon Clark, and it is dated the 15th of July 2013. Okay?
Mm-hmm.
Now, you can take that for me, or I can take you to page 14 where it has that
No,
at
no.
the end. All right. Now, at paragraph 38, page 13, internally within it, there's a reference there to Mr. Jenkins. Okay?
Mm-hmm.
Now, this is a reference to the Fujitsu employee who you had some reference to already in your evidence, and going back in time to Mr. Castleton's case, had some involvement in the Castleton case. Okay?
Don't recall him.
Well, you've just been asked a number of questions about Mr. Jenkins, the Fujitsu expert who you were saying could not be used as an independent expert.
Oh, that's Gareth Jenkins.
Yes.
Ah. Right, okay.
Right. So we're talking about the same person.
Okay.
Okay. Now, in this advice, Mr. Clark, who is a barrister working at a firm called Cartwright King, is setting out particular views that he's come to with dealings with this Mr. Jenkins. Now, you'll see there, paragraph 38, second of the two, if I call them bullet points, second of the 2 points. Accordingly, Dr. Jenkins's credibility as an expert witness is fatally undermined. He should not be asked to provide expert evidence in any current or future prosecution. Okay? So the date of this opinion being given, 15th of July 2013. And it's quite a serious opinion being given of someone in Mr. Jenkins's position, an employee with strong knowledge about the Fujitsu Horizon system. Okay? Now, you mentioned in your evidence earlier on that you're not a criminal practitioner, but you are certainly a civil practitioner.
Yes.
And you're certainly a civil practitioner who's had dealings with, at least we know, the Castleton case you've been talking about, and we know also that the Post Office came back to you at an earlier point in 2012.
Yes.
Okay. So by the time we get to 20th of March 2014, this opinion is being given within, if you like, the Post Office by a legal advisor to the Post Office. Now, were you told, Mr. Morgan, that there was a settled and serious opinion given about Mr. Jenkins, the Fujitsu expert, who had a lot of knowledge about the Horizon system?
No.
That.
I can make it completely clear that I received no instructions, I received no papers. I did receive 2 or 3 telephone calls, however many were recorded in my evidence, which I only recall because I checked them against my computer system in Chambers. And I was only asked questions. I had no information tendered to me. There was not a, here's some further information, provide some more advice. It's, if we ask you this, what would you say?
2 last questions.
Of course.
Now, you and I had a number of questions, and you answered a number of questions when I first started a couple of minutes ago. And I was asking you about what you recalled about this meeting, and frankly, you're saying, really, I don't recall very much.
Yeah.
If you'd have been told at around this time in 2014 that regarding Mr. Jenkins, we got real doubt about this guy, I mean, I don't know what would be the succinct way you would put it, Mr. Morgan, but there's a real problem here. That might be quite memorable. Do you agree?
If I'd been told that, yes.
Second question, did the Post Office ever come back to you as a senior civil practitioner with at least some knowledge of these systems and say, look, we've got this problem with this Fujitsu expert. What would that have done to all of our civil cases that we've dealt with going back in time? Did anybody come back to you and ask that question?
No.
Excuse me one moment.
Sure.
Thank you, Mr. Morgan.
Thank you.
Who's next?
Sir, I am. Henry.
Over to you, Mr. Henry.
Thank you, sir. Mr. Morgan, as a contentious chancery and insolvency practitioner, you will be familiar with the case of Gessmin and Credit Suisse, won't you?
No.
Surely you must be. The judgment of Mr. Justice Leggett, where he was discussing memory.
Oh, yes.
Yes,
Yes.
thank you. And you will remember that
Sorry,
in
that wasn't
that
intended as a joke.
Sorry?
That wasn't intended as a joke, although it might have appeared
No.
as much.
Yeah, well, no, quite. You will remember that in the course of that judgment, he said that civil litigation, particularly in the preparation of witness statements, gives rise to powerful biases. You remember that?
Let me also be perfectly honest. I do very, very few witness actions. So although I am familiar with the judgment and I'm familiar with the overall thrust of it. I do not have specific passages in mind, but I'm quite content to accept that the preparation of witness statements is something that can give rise to evidence being fluffed, if I can put it like that, evidence being improved that shouldn't be improved.
Now, I don't suggest that of you, Mr. Morgan, but I do suggest that you have fallen victim to powerful and distorting biases. Let me explain why. Can you help us, please? So far as your witness statement is concerned, your recollection or reconstruction of your involvement in the Post Office Limited and Castleton is that this was essentially a Shaw and Picton case, the case of agency.
It was from about the summer of 2006, yes.
But you must accept, I mean, you have read the judgment of His Honour Judge Havery, Queen's Counsel, several times, haven't you?
Yes.
And in fact, you read it because you read it before composing your statement in May of this year.
Yes, I needed to
Yes.
remind myself about what had gone on.
Yes, exactly. And you can see, can you not, from that, that Mr. Castleton's case put the reliability of the Horizon system fairly and squarely in issue, didn't it? Didn't he?
Mr. Castleton sought to suggest that the losses were illusory and were caused by the Horizon system. At no stage prior to the trial did he articulate or identify how it was that those losses were being occasioned.
But you must have read the call, the Horizon System help desk logs concerning his case and the complaints that he was making contemporaneously, Mr. Morgan, surely?
I would have read them in the trial bundle, yes.
Yes. And you must also it's clear from the judgment itself that beginning at paragraph 12 and proceeding thereafter, 13, 14, 15, etc., he gave detailed accounts of what was going wrong with the system. It's clear in the judgment.
He gave accounts of what he said was going wrong and that he phoned the help desk, and there was a complaint that the help desk wasn't helpful at all, yes.
But also the nature of the glitches, the nature of the anomalies that were occurring. He was describing them,
Yes.
as it were, in real time.
Yes.
And also how he would take balanced snapshots. In other words, he would take screen grabs of the screen, pictures of the screen, showing how inexplicably there were alterations in the figures presented by Horizon. That was also part of his case, wasn't it?
Let me be honest with you here. I don't recall him ever presenting evidence to that effect to the judge. I don't recall that. I'm not saying he didn't do it. I just don't recall that.
You remember when Mr. Beer was reading out part of the transcript just a few moments ago, and I don't necessarily suggest that you ought to have picked it up, but he was referring to balanced snapshots.
Yes.
Right. Now, at paragraph 4 of the judgment, and the judgment is POL 000211678, and I don't suggest that it is put up on screen, but purely as a reference. There is the following. The learned judge stated, losses apparently shown by the balance lists and cash accounts, bracket final, were illusory, not real. It was entirely the product of problems with the Horizon computer and accounting system. The apparent shortfalls were nothing more than accounting errors arising from the operation of the Horizon system. That's what the learned judge said when he was recounting or encapsulating Mr. Castleton's case. You wouldn't disagree with that?
Well, you're reading from the judgment, so no.
Yes. Now, the bias that I suggest is that that was not taken seriously. I don't suggest by you because you did ask questions. It is clear that you asked questions, including whether Fujitsu could, as it were, interfere with the system or, as it were, have access to the system without Mr. Castleton's knowledge. And you asked those questions. But can you help us, please, to to what extent were those serious concerns followed up by your team? Because, of course, you as counsel were leading your team, weren't you?
I was instructed to appear at trial. Yes. I was instructed to amend the pleadings. Yes. I don't know. I mean, I asked questions. I didn't get answers.
And we know, and I don't ask for it to be put up on screen, but we know from Mr. Castleton's pleadings, LCAS 40294, Mr. Beer has taken you to paragraph 5, paragraph 6, but also paragraph 7b, that Mr. Castleton was vehemently disputing that these losses were real. They were not accurate. They were artifacts of the Horizon system. You don't disagree with that, do you? That's what he was saying.
Yeah. No, I agree.
And that demanded, obviously, the most serious scrutiny, did it not?
That's what a trial is meant to achieve.
But in the run-up to a trial, because of course it's too late sometimes, or too often too late when it arises in a trial, but in the run-up to a trial, there ought to be full and frank disclosure, shouldn't there?
There is disclosure in accordance with the requirements of the CPR, yes.
Yes. Now, I'd like you to help me, please, because, of course, I don't know if you were watching Mr. Dilley's evidence yesterday.
I saw part of it, but not all of it.
Have you read it subsequently?
No.
No. You may not have been present when this was going on, but the Post Office, he told us, was receiving 12,000 to 15,000 calls to the Horizon System help desk per month, telephone calls from sub-postmasters about defects and technical problems with the Horizon System, and Mr. Dilley decided that he wouldn't disclose these calls, neither generally as to volume nor specifically as to content, to Mr. Castleton, because at one point he thought that it might overwhelm Mr. Castleton in a sort of benevolent and pastoral way, and on another occasion because it was going to cost, in fact, £3,000 to collate them. Did you hear that evidence?
No, I didn't.
No. Now, having been informed of that evidence, may I ask you, and I mean no disrespect, Mr. Morgan, were you involved in that decision?
No.
No. Should you not have been consulted before such a decision was actioned by Mr. Dilley?
Look, at the end of the day, the relationship between solicitors and counsel is a matter of instructions and action on instructions. I was not instructed by solicitors in relation to disclosure. Simple as that.
Would you like to have been instructed to give your review on that somewhat momentous decision by your instructing solicitor?
I don't think counsel ever likes to be instructed on disclosure issues, but if one is instructed on disclosure issues, then one examines each individual document against the specific requirements of the disclosure order made by the court.
Would you agree with the decision that Mr. Dilley made?
I don't know. I haven't read the call logs.
So may I take it, therefore, that, and this is your opportunity to give your considered view, that...
Well, it's not my opportunity to give a considered view because I haven't seen the call logs.
Right. Well, let us move on. Do you think you were being kept at a distance from disclosure decisions by those instructing you?
I have no idea because I don't know what the disclosure decisions were or taken in what context. All I know is that Post Office Limited had instructed Bond Pierce and Mr. Castleton had instructed his own solicitors. And as is usual in litigation, solicitors had gone through the disclosure exercise. If there were perceived to be deficiencies, then there would be correspondence between them. And if necessary or appropriate, orders for specific disclosure or further disclosure. I was not involved in any of that at all.
Thank you, Ms. Morgan. But just returning to the questions that were put to you by Mr. Beer, counsel to the inquiry, you asked a lot of questions, but it seems that answers came there none. Would that be your recollection now about disclosure?
About disclosure.
Yes, the questions that you asked about the integrity of the system, about remote access.
Well, that's not disclosure. That's some questions about what's actually going on. Disclosure I take to be disclosure of documents. Disclosure is a disclosure process. Disclosure of information about the case in relation to specific inquiries about Fujitsu, yes, I'd accept that I asked a large number of questions. I sought to ensure that the original equipment was maintained and steps were taken to preserve the software, but I didn't get anything after that. Nobody came back to me and said, well, what should we do now?
And so I ask you, therefore, did that set any alarm bell or did that fly any red flag?
No, because in the ordinary course of litigation, if there are disputes between the parties about particular procedural steps, then those are raised in correspondence between solicitors, and if they're not answered, then they're taken before the court at the CMC or PTR.
Right. Now, just dealing with that, you were saying that those were questions about the evidence in the case, but if you had got the answers, yes, they do have the ability to insert transactions without anybody knowing the fact that they can do that. That obviously would have been patently disclosable, would it not?
I certainly wouldn't have been able to run a case contrary to it. Disclosable.
You couldn't run a case if that was in your knowledge. You would have had to have considered your position.
Yes, exactly.
Exactly. So, let me just ask you, please, now, it's the time of trial. You're about to give your opening, or you've just given your opening, and we saw it, again, no need to put it up on the screen, it's been a long day, POL 000070126. You saw the attendance note of Mandy Talbot and the issue about Falkirk, and it's the 6th of December 2006. You've seen it. By all means, if you would like to see it again.
I'm quite happy I can remember it.
You can remember it. And you were saying, you are reported, forgive me, Mr. Morgan, RM saying he was concerned about whether we have to give disclosure of this fact. He thought probably yes, but wanted to find out if the judge thought it was relevant. RM was prepared to put off the decision on this until after his opening. RM asked Mandy Talbot to get some definitive answers from Fujitsu. RM saying that we may finish in court by lunchtime tomorrow. Falkirk, that was the Calendar Square bug. And if I recall your evidence correctly, you were not certain that your solicitors disclosed that to Mr. Castleton.
Yes.
It appears, does it not, that it arose in this way, that Mr. Castleton was tentatively putting his case about a post office, and then it was immediately understood and recognised by Mrs. Chambers that that was the Falkirk branch, the Calendar Square. Correct?
I think so.
Yes, it's in the judgment.
Yeah, fine.
It's in the judgment. It's paragraph, I think, 23 of the judgment. So it arose, as it were, ex improviso, purely serendipitously and by chance, that Mr. Castleton asked that tentative question and then that was revealed. Correct?
Apparently so, yes.
It's hardly ideal, is it?
Trials are hardly ideal. No, you're absolutely right. Things crop up that you have absolutely no idea about as counsel. Somebody just doesn't bother to tell you.
And similarly, the Tivoli logs arose for the first time in the course of Mrs. Chambers' evidence, and she had to be recalled, didn't she?
Mr. Castleton asked for her to be recalled, and she was recalled. I think somebody else was as well, wasn't they?
Yes. Ruth Skinner, or Simpson, forgive me. Ruth.
I can't remember, but I
Yes.
seem to remember there were two.
And he tried to cross-examine her, and you objected to the cross-examination?
Quite possibly, yes.
Yes. Now, the position is that disclosure in this case was a dismal failure. That must be obvious now.
I can't help you. I did not take part, nor was I instructed, on the disclosure exercise.
But when the trial is ongoing, and you must forgive my ignorance, but in the criminal courts, when the trial begins, counsel is sole arbiter of disclosure. Is that not the same in the civil courts?
No.
No, I see. But the position is, you would agree, an ex improviso revelation by a witness, and also for the very first time, logs referred to by a witness, hardly satisfactory.
No, and that's why they were disclosed.
Right. The known error logs were not disclosed, though.
I don't know.
Well, there's a reference to a Kell in the attachment to Mr. Dunks's statement, and Mr. Dunks was a witness in the case. Perhaps the attachment, I don't suggest that you deliberately failed to disclose it, but you must have read Mr. Dunks's statement and the attachments there too.
I must have.
Yes. And maybe Kell wasn't explained, but it means known error log.
Fine. Presumably, Mr. Castleton's solicitors would have read the same witness statement.
Well, we don't know.
And would have been capable of writing a letter had they thought it appropriate to do so.
By this time, of course, Mr. Castleton is a litigant in person.
He became a litigant in person on the 20th of November, didn't he?
Yeah.
And witness statements were exchanged substantially before then.
Mr. Morgan, who has the obligation to make a disclosure of a known error log?
The Post Office.
The Post Office. So, please, without trying to shift the onus onto either Mr. Castleton himself or his former solicitors, Messrs. Rowe and Cohen, it was clearly and obviously the Post Office's and those they instructed their duty to disclose that information, wasn't it?
If it fell within the terms of standard disclosure, then yes, it did.
Yes. How did this happen, do you think? And these are my final questions. How did this happen, do you think? You surely, by now, knowing everything you know, Mr. Morgan, regard the decision in the Post Office Limited and Castleton as a miserable miscarriage of justice.
I don't know. I don't know that it's a miscarriage of justice. I'm not here to express a view on the rights and wrongs. Counsel, instructed in a case, is not there to express a view on the rights and wrongs. I was asked to prove a case that I did on the basis of documents signed by Mr. Castleton, whose truth were not challenged by Mr. Castleton.
Mr. Morgan, you know that the learned judge, in the course of his ruling, his judgment, which you then wrote an advice note on the 22nd of January 2007 for the benefit of those who instructed you, he found, paragraph 23 of the judgment, there is no evidence whatsoever of any problem with the system. And at paragraph 11, he stated that it was inescapable that the Horizon system was working properly in all material respects. Knowing what we know now, I ask you again, no disclosure of the known error logs, no disclosure of remote access, no disclosure of the receipts and payments mismatch bug. Do you not now reflect that the decision of His Honour Judge Havery, Queen's Counsel, was a dreadful miscarriage of justice?
I think you have to read the judgment in its entirety and see that he based his assessment on documents signed by Mr. Castleton as an agent, recording a debt due to the post office. And there was no difference between the amount that was shown in the document signed by Mr. Castleton and the amounts shown on the Horizon log. Now, of course, if Mr. Castleton signed false accounting documents, then I would accept that there was that the error, that the judgment is wrong.
Well, that is precisely what Mr. Beer was trying to explore, and successfully, if I may say so, explore with you. Ms. Morgan, I ask you for a third time. Is this not, again, the astigmatism, the bias that arises in this process, which is not meant to be adversarial, I assure you, but just knowing what we know now about the Fraser judgments, the common issues judgment about the oppressive nature of the contract upon which you relied, the Horizon IT judgment, which went through a litany of non-disclosure, other misfeasance, and bugs, errors, and defects. I ask you for the third time, and I won't ask it again, do you not reflect now, knowing what we know, that the decision of Mr. Justice Havery, the decision of His Honour Judge Havery, Queen's Counsel, was a dreadful miscarriage of justice?
I think that the decision of Mr. Justice, or His Honour Judge Havery, was the correct judgment given when Mr. Castleton did not say, my figures were untrue. Had he said my figures were untrue, then we would not be in this position.
That it, Mr. Henry?
Yes, sir. Thank you, sir.
Thank you. Any other questions?
No, there aren't, sir, except that we've now tracked down that document that I said I would come back to.
Yes, well, let's just have that up, please.
It's poll 308 1826. Thank you. And if we go to page 17, please. No, that's the wrong document.
I'm beginning to wish I hadn't asked that question.
Me? Right. Just give us a couple of moments, sir. It was thought that the correct document had been uploaded whilst the last 45 minutes had occurred, and it seems that's not the case.
All right. Well, the reality is that the document will, in due course, surface and be put on the screen at some suitable moment, and we'll all be able to see what, was it Clause 5 or Schedule 5 says?
Maybe, sir, if I can just read.
Yeah, that would be fine. That would be lovely. Thank
as,
you.
What some people will call a workaround. The email was the 10th of November 2006, and at 1600 hours it enclosed the draft Tomlin order. It included the proposed text amended by Mr. Dilley and said, I attach a draft consent order for your approval. The real question is whether we need the undertaking in Clause 5 of the schedule. Richard thinks that by making a song and dance, we highlight a sensitivity, and the less we talk about it, the less likely it is that Castleton will seek to raise it. And then Clause, it's a 5-paragraph consent order, Tomlin order, to which there is a schedule. And paragraph 5 of the schedule says, the defendant undertakes to the claimant that he will neither repeat his allegations about the Horizon system, nor make any further allegations about the Horizon system or its functioning. And in the event that the defendant breaches this undertaking, he shall both, 1, submit to an injunction restraining him from talking further about the Horizon system, and 2, pay to the claimant liquidated damages in the amount of £25,000, being a genuine pre-estimate of A, the claimant's costs of having to rebut such statements, and B, its loss of goodwill generally. So I think the question is, the chairman asked you.
Yes.
You were asked, I think, for your view on that, and it's plain that although the wording that Mr. Dilley was proposing isn't exactly the same as in the draft Tomlin order, in particular because there are some consequential sub-paragraphs concerning injunctive relief and liquidated damages. You thought that, according to this record, that by making a song and dance, the Post Office highlighted a sensitivity. The less we talk about it, the better.
Yes. I would have also thought that the undertaking itself was unworkable and a complete waste of space, but I don't know whether I'd have expressed it that clearly.
And unenforceable.
And unenforceable. And an undertaking to a party rather than to the court. So there we are.
For a range of reasons.
For a range of reasons, I would have been extremely adverse to it.
I think the question is, isn't this other evidence, however, of what the Post Office's real motivation was, i.e. to gag somebody from speaking, or alternatively, to require them to say something good about the Horizon system?
Regrettably, my experience of people trying to negotiate settlements is they ask for the moon when they've got no need for it. As I said, I was rather focused on trying to prepare for the trial, and this was just unnecessary noise in the background. I wasn't focusing on what the parties' terms necessarily were. With the benefit of hindsight, then I might have put more thought into what people's motivations were, but as I keep on saying, I was focused on a debt recovery claim.
Well, Mr. Morgan, you'll be glad to know that ultimately the motivation of the Post Office in respect of various of its actions is not for you or Mr. Beer, but it's for me.
So I haven't any further questions. Did you have any follow-up questions in relation to Clause 5 of the Tomlin order?
That's fine. Thank you very much.
So I do apologise. I'm a terrible one for having one thought or two on the stairs. There was one thing I forgot to put.
Could I put it quickly? It won't take more than a minute.
Well, I will hold you to 90 seconds, Mr. Henry.
I'm
You
very
better
grateful, sir.
Quickly.
Mr. Morgan, I'm so sorry. It just refers back to Mr. Dilley and what he said yesterday. He said at page 124 of the transcript that he asked you, and counsel advised us not to disclose the BDO Stoy Hayward report because he quotes, he didn't think the Post Office needed it to prove its case. And then he said again at 136, I believe that I discussed this report with counsel. I cannot now recollect after the passage of time all the details of this discussion, but counsel was made aware of it and he advised not to disclose it. I'm sure that if he had considered that it should have been disclosed, he would have given me that steer. That's what Mr. Dilley says about that draft report. What do you have to say about that?
First of all, I don't remember ever seeing the draft BDO report. Secondly, I remember asking for accountants to prepare a report to summarise the ins and outs of all of the cash movements and stock movements, because that would have enabled me not to have to do it myself, and I was never provided with that. Thirdly, in civil litigation, you don't have to disclose any draft experts' reports, or indeed signed experts' reports, even if they're finalised. Until such time as they are exchanged, they are covered by privilege. Had he asked me, and I don't remember him asking me, I would have said, you don't need to disclose it. But in any event, I don't think I even saw it. I don't remember even seeing a draft BDO report.
Again. Well, That's a comprehensive answer. So I think that provides an answer to your question, Mr. Henry.
It does, sir. Thank you so much.
Can I also just say one thing? I have tremendous sympathy with what Mr. Castleton has gone through and his family. I can't say anything more than that, but I quite understand why he's upset by what's gone on. I hope that goes some way towards it.
Right. Thank you very much for coming to give evidence, Mr. Morgan. We'll now adjourn until Tuesday. I think it's Tuesday, yes. And it's Mrs. Chambers, is it?
10 a.m.
Yeah?
Tuesday, Ann Chambers.
Yeah, fine. All right. Thank you all very much.
Thank you.